it's all right with people, we're going to record the presentations today, but not the questions and answer at the end. So that's the intention. It's a huge pleasure to be hosting the discussion today on this really important book, Article 8 ECHR, Family Reunification and the UK's Supreme Court Family Matters. Congratulations, Helena. It's a fantastic achievement to have written a book, especially under current conditions of high workloads, and you were DOR at some point as well. So it's fairly magical that you managed to produce a book. So fantastic work. And always smiling as well as we go through. So it's fantastic to have you as a colleague. But without further ado, I'll give you a quick introduction, and I think you're going to say about 20 minutes, and then we'll hear from three discussants: Professor Marie-Bénédicte Dembour, Professor Betty de Hart, and Dr. Joe Wilding. And I'll give you each an introduction as we get to you. You'll get 10 minutes each, but I think, Helena, you're going to have 20 minutes. I'll just give you an intro. So Helena Wray is Associate Professor of Migration Law at the University of Exeter's Law School. She's taught, researched, and published extensively on migration law, especially family migration and citizenship. And she's about to begin work on an ESRC funded project on UK-EU couples after Brexit. And our discussion today is about her new book, which was published in February. So over to you, Helena.
Thank you very much. Thank you, Nick. Thank you, everybody, for being here. Thank you for coming. Thank you to my fellow speakers. I owe them a lot, as they helped me clarify my thinking as I wrote the book. And you should probably be grateful too, because actually, if however coherent I may turn out to be, a lot of that is down to them. So why did I start writing this book? Just a quick moment, Hannah, do you want to start sharing the slides and move on to slide 1?
The white person's issue.
Thank you. Okay, so if you like to move on to the next slide, Hannah. Why this book? Well, in essence, I saw a fascinating and really quite unique stream of cases that in its early stages seemed to show the Supreme Court was really ready to use the potential of human rights to protect the family life of cross-border and binational families. And these cases really seemed very exciting to me. And then they progressed through the years and they faded away rather disappointingly, even if they weren't technically reversed or overridden by statute. And I kind of wanted to figure out what happened. You know, I felt this was something that was really interesting, really important. And what happened to it? Where did it go? So I decided to do this, obviously using the usual sort of legal analysis that you would apply to cases of this nature, but also using other ways, including a content analysis of the cases. And there's a lot more about this in the book, where I looked at these cases as statements of law, but also as purposefully made constructions and artifacts that reflect the preoccupations of the authors, the people who are writing them, and of the society in which they were made. And these cases mattered to me because I've always been interested in the intersection of and the tension between state-generated immigration controls and the human need for intimacy and care within families when that family life exists across borders. And I mean, it's something that's played out in a number of disciplines, and you have the concept of state sovereignty versus intimate citizenship. You have family as a nation building project that's very much racialized, it's gendered, it's a classed project, versus family as an individual project of individual fulfillment and care. And that this tension, therefore, is particularly acute in this area of family migration. Now, all governments permit some family migration. They have to, but they often seek to control it very restrictively. And international human rights law is very much dependent on state consent, and so it's intervened only in a very limited way on questions that touch on immigration, including in respect to families. So my focus is on Article 8 of the European Convention on Human Rights, the right to respect for family life. And now this is a qualified article. The family life requires protection, but the interests of families can be outweighed by the public interest, including immigration control. And since the 1980s, we've had the European Court of Human Rights developing a very cautious jurisprudence on that, which means that in a few cases, states have to allow the stay, or more rarely the entry, of non-nationals in order to allow families to live together on their territory, even if this is not permitted by their immigration laws. And just to note, I'm talking about immigration laws here, and I'm not going to be discussing criminal deportation. So then we had the Human Rights Act in the UK, and that meant that UK courts now had to address this question. So, you know, when does the need of families to live together outweigh the power of the state to control borders? This was now a question for the UK courts, and it placed them therefore at the heart of this dilemma, and pretty much where they do not want to be, given the common law tradition in the UK, given our system of precedent, and given the UK's political constitution with its emphasis on parliamentary sovereignty. It actually started placing the courts in a position they were really not accustomed to be in. And before the House of Lords cases and Supreme Court cases that I'm going to be discussing here, the lower courts really reflected this judicial reluctance, and they adopted the most conservative versions, really, of the Strasbourg cases, and they also confined themselves to what I would call a review function, basically asking the decision maker if the decision maker has lawfully arrived at their decision, taking account of human rights obligations, not really saying, what do we think human rights demands in this situation, but has the decision maker taken all the factors into account, applied their mind correctly, and reached a decision that's therefore lawful. And what this effectively meant was that no cases succeeded, almost no cases succeeded, very, very rarely indeed. And really, all the invocation of human rights meant was that there was a legitimization of sometimes really quite brutal separation of families. So that was the situation. And then eventually, in the case of Huang, an appeal came in 2007, an appeal came before the House of Lords, which was what the Supreme Court was then called, on this question. And in a relatively concise single judgment, the court opened the way to a more active role for judges in assessing effectively, are governments justified when they refuse claims for family reunification under Article 8. And it found that when doing this balancing exercise, appeal courts should reach their own decision. They shouldn't just be looking at whether the decision maker has reached a possibly correct decision, but what do they think? Where do they think the balance lies between the public interest and family life? And in doing that, they should give what they called appropriate weight to the government's view, but they shouldn't defer automatically to the government's opinion on where this balance should lie and the weight, how important the public interest is. And therefore, it meant that courts were no longer tied to the government's assessment of what Article 8 meant. It became something that could really be discussed and debated and contested within the courts. And Article 8 could become what one judge called more than what one judge called a ritual incantation, but a way to ensure that the needs of families could be heard and taken into account, you know, in an independent judicial forum. And that was really good news. It was a good case. But what was really interesting to me was that after that, the court followed up with a series of 7 decisions between 2007 and 2011. Could you move to the next slide, Hannah? Which centered on family life and showed actually what could happen if you have a more protective court. If you could then actually move to the next slide after that, thanks. So this should be the phase 2 cases. So what I've done, I've put the cases, these 7 decisions on a slide, and I divided them into 2 phases. And the lawyers here will see that these are not all Article 8 cases, and I do explain the reasons for their inclusion in the book. And I also explain why I've divided them into 2 phases, which I can't really do here at this point, but I will touch on it later. So effectively, we had these 2 phases of cases that followed. And cumulatively, what these did was that they adjusted the balance between the state and families in really some quite significant ways. And just to give a few examples, previously, if a family wanted to argue that it had to live together in the UK, it had to show insurmountable obstacles to living elsewhere, a really high threshold. This became a test of reasonableness. Is it reasonable to expect them to leave? It became easier for applications by irregular migrants without status to remain in the UK, to be heard in country, rather than expecting the irregular migrant to go back to their country of origin, which could be a very troubled country, a very difficult place to be, and wait for months, make an application, wait for months for it to be decided. It's protected the right of irregular migrants to marry in the UK. It found that financial support from other family members and from the community had to be taken into consideration when considering the financial position of the couple. It ensured that a child's best interests must be treated as a primary consideration in immigration decisions that affect them. I mean, that's just a few of the things. There are other things too. I obviously, time is limited. So, you know, these were really quite significant. And at the same time, the court used a new humanizing language and presentation. So previously, really they had been talking about the government's power to regulate immigration and the fact that these were often illegal, in inverted commas, immigrants. And there was, not a lot of sympathy, frankly, shown for the dilemmas they faced and the difficulties they had. And now the court did something else. It brought these individuals to the fore. Literally, they talked about them first. They didn't start off with the government's position. They started off with the position of these individuals, of the people that were involved. And they said actually quite a lot, a surprising amount, in my view, about who they are, their situation, their history, their families. When you consider that the Supreme Court's interested or concerned with points of law of the greatest public or constitutional importance, and the facts have been determined at a much lower level, this was really quite unusual. It was really quite significant. And at the same time, in Huang, the court recognised the underpinning value which Article 8 represents. And if you could change the slide, Hannah. So what this it says, I've got the wording up there. I think it's a very powerful passage, actually, and really quite unusual coming from the court, that human beings are social animals, they depend on others, and their family or extended family is a group on which many people most heavily depend socially, emotionally, and often financially. There comes a time at which, for some, prolonged and unavoidable separation from this group seriously inhibits their ability to live full and fulfilling lives. I've never seen a higher court talk in this way on immigration matters and talk about the individuals involved in this way. And it really did make me question my assumptions about what law can do. And it kind of dissipated some of my cynicism about human rights as a legal enemy, legal remedy. But it was, in many ways, exciting new territory. However, as is the way of these things, this new approach did not endure. And if you could change the slide, Hannah, there were 3 decisions made between 2015 and 2017, which did represent a significant rollback. I mean, I don't want to overstate it. Not everything was lost. The government absorbed a narrow interpretation of Article 8 into the immigration rules. And the court accepted that this would almost always apply. So there was something, not very much, but it would. The government accepted that this is what it had to do, and the court accepted that this was okay. The court also accepted a reduction in judicial authority over Article 8, and it went back to its much more impersonal language, that sounds more objective, but is really about taking out the human beings, or talking about them in quite dehumanizing ways sometimes. And the judgments were largely written again from a government perspective. So these earlier cases, they kind of disappeared over the horizon, really. They, some of them really are hardly ever cited now. So of course this all happened, as I say, 2015 onwards. And it took place under a changed political climate. We had the Conservative coalition government. We had the net migration target, we had the hostile environment, we had pushback on Article 8 from the Home Secretary, in particular Theresa May, and some of you may remember Catgate, and therefore the picture of the cat. And there had been changes also in the composition of the Supreme Court, which had become, and a number of people noticed this, much more executive oriented. There were also some legal changes, which I won't go into here because they were of limited relevance in these particular cases, changes to the immigration rules and also some statutory changes, but these didn't come before the court. So, I'll just skip over those for now. I think basically what I would say is that at the time when it made these judgments, these new judgments, the phase 3 judgments, the court could have kind of continued pushing, but it would have been well aware of the futility of doing so. The wider damage of sort of getting into a battle on this question, and I think also a change in the perspective. This is not something that the court should be engaging with. And so we've back to a position where, we're not totally back to where we were before. Some individual claims still succeed. There is on a kind of quite narrow basis of Article 8, but Article 8's become a much more exceptional remedy, a much more legalised remedy, and it's tied much more closely than before to the government's view of what it should mean. It's lost its kind of, the court has lost a lot of its sort of autonomy in terms of its interpretation. So, that's where we were, and I kept thinking about this strand of cases and my questions about it, and you have to read the book to get the answers, but these are some of the things I thought. And Hannah, could you move to the next slide, please? Thank you. So, were these cases significant? Why was I writing about them? And I did ask myself that question quite a few times. In pure constitutional terms, they're of limited significance. There was a lot of political hoo-ha. The government kept saying things about, the court doesn't understand Article 8, or it's acting unconstitutionally or whatever. But all the court was doing was performing its pretty, well-established function of interpreting and applying the law. In this case, the Human Rights Act, a statute, the highest form of UK law, and applying it to executive policy that doesn't have, the democratic level of democratic approval that a statute has. I would say, and I would acknowledge, that when they were doing so, they were pushing at the outer limits of the of interpretation of the Strasbourg court cases. I wouldn't say they went beyond, that's too binary, but they were looking, they were looking at it at the more generous end. But I would say, and I discuss this at length in the book, can't do it now, this was very consistent with its powers under the Human Rights Act. This didn't require courts to follow Strasbourg in a kind of mechanical sort of way, but to take account of the Strasbourg cases. Strasbourg Court is a supervisory court. It awards national authorities a significant margin of appreciation, that is to say, discretion in how to apply human rights in the domestic context. And Parliament, through the Human Rights Act, had awarded judges new authority in the implementation of these human rights, and the court was using that authority. So, there wasn't anything nefarious, unconstitutional, or whatever going on there. Obviously you wouldn't expect it, really, would you? Really, this was a battle over the meaning of the Human Rights Act. And within that battle, it was a struggle for authority, really, between the court and the government, played out through this issue. Now, when I say struggle for authority, it was about, who gets to decide what. And, but it was, that doesn't mean to say there wasn't also, and I think there was a strong moral commitment by the court at that time to protecting family life when it could. And it was using its powers to provide a small, relatively small counterweight to the otherwise overwhelming state power in the migration context. And we have a very heavy political constitution, and immigration is considered as a kind of untouchable area in many ways. So it did represent a change. And in doing so, it brought the interests to the fore that were otherwise really hardly ever considered, family life, families, migrants, sponsors, the choice between separation or exile, and essentially where the government just saw migrants, and often illegal migrants at that, the court saw individuals, people, citizens. And when you read these early cases again, you go back to them and the language, you realise how much is missing in more conventionally written judgments. It also, these cases, I think, reveal the extent to which judges are strategic, what I have called strategic political and moral actors. They don't make their decisions in any sort of political, social, moral vacuum. They're very attentive to the position and preferences of other key players. And this was evident not just in what they said legally, but how they said it, how they wrote their judgments. I talk about this quite a lot in the book. It's one of the most interesting bits of the book to write. And I can't really give you, say too much about it because of space. But Hannah, if you could move to the next slide, I have provided there one slide that I think says quite a lot. So in many of these cases, not all of them, they involved migrants who didn't have permission to be in the UK.
Helena.
Okay. They had come to the UK and they didn't have permission. How important was that in the judgments? And you can see barely important at all at the beginning, and then becoming more important, and then at the end, you know, the court really going to town on the fact that these were illegal migrants. So, you know, what was going on? I think that, could you move to the next slide, Hannah? Thank you. What, you know, why did it end this way? Well, obviously, you know, why did it start this way? Why did it end this way? I think this was a court in the beginning that, you know, was willing to challenge the government because this was the government's own policies. The government had introduced the Human Rights Act, and then it had introduced these immigration policies. It wanted these immigration policies legitimized, you know, in human rights terms. The court would do that, but it would do so in its own terms. So I think that was, you know, one factor feeding in. I think the other factor was that we did have the presence of judges who'd come up through the family courts. And I think the disjuncture between how you talk about family in the family courts and how you talk about family in the immigration context is so very marked. And they brought some of the family court values into these decisions, this particularly Baroness Hale and Lord Wilson. But why did it go wrong? And obviously the politics, the composition of the court, the legal changes, but there are some other factors as well. And, you know, I've got very little time. I will just say about them very briefly. I think what, you know, and there are other reasons too, but there's three that I've picked out here. In the first cases, in the early cases, in particular in phase one, the court didn't really explain what it was doing. I mean, it was doing something interesting, but it didn't really show its working out. There was virtually no reference to the Strasbourg cases or to the operative mechanisms of the Human Rights Act. And they talked about the claimants very sympathetically, and these are lovely passages to read. But I kind of concluded that actually they had to do too much work in these cases because the court was kind of invoking sympathy for these families, making the case for better treatment in these individual cases, but not really explaining why this was, you know, an exercise of sort of new authority and exactly where that authority came from, except in quite general terms. And that meant that these decisions had perhaps a more limited effect and were seen as being confined to their facts and so on. I also think we have to recognise Article 8 is a fragile vehicle. It's weak, really. It doesn't explicitly, in many ways, it doesn't explicitly apply to cross-border families. The jurisprudence has evolved only very slowly and cautiously. It doesn't have a lot of internal coherence, and I think, therefore, when the court tried to rely on it, it didn't have all that much in terms of principles to draw on. And in fact, in the phase 2 cases, I did say I'd say why it was phase 1 and phase 2, and in phase 2 cases, the later cases, they actually were not relying wholly on Article 8. They were relying on other human rights articles, or saying, well, it is Article 8, but it's not really an immigration case. We're obviously very unwilling to keep focusing on this kind of immigration Article 8 kind of juxtaposition. It was, you know, they didn't feel they had very strong ground. And I think the final point of this is that the limits of them were not well understood. And I won't go into this here, but I think that the lawyers involved in bringing some of the later cases did not fully appreciate the limitations of the cases in the earlier phases. So just to conclude, can I have the next slide, Hannah? Just to conclude, what does this tell us about the potential of Article 8? You know, what can we hope for? Well, it is quite tempting to be cynical. We've arrived at a position now where the government can make very meagre exceptions, really, to very harsh immigration policies, and at the same time claim that these policies are legitimised as being human rights compliant. There is no doubt, really, that these kind of legalised human rights claims can only have a limited impact unless they're also supported by a wider political discussion and acceptance of why human rights matter, even when they're counter-majoritarian, and why we need to move away from this kind of exceptionalism of immigration as being a matter of almost unlimited executive discretion and treat it as a mainstream part of political and social life with the benefits and the trade-offs. And obviously we're a long way from that. And therefore there's work that we all need to do. We can't expect the courts really to do the heavy lifting in that regard. But it doesn't make the legal processes irrelevant. Judicial decision-making, I think, can concretize and embed these wider shifts in the perception of the relationship between immigration and family. And I think Article 8 can do that. And I have got a chapter in my book about what Article 8 could do if we were in a kind of more favourable context. And it does have the potential to offer better protection. The Supreme Court started to show what it can do. And I think the cases matter for that reason, even if they couldn't do more in the times that we're in. So I'll finish it there. Thank you very much.
Thanks, Helena. That was a great overview. So we're going to listen to 3 respondents now, each with 10 minutes, and we'll go straight on to the first respondent, which is Professor Marie-Bénédicte Dembour. Professor Dembour joined the Human Rights Centre of the University of Ghent in Belgium in 2019. Prior to that, she studied at Universiteit de Brussels and University of Oxford, and has won a number of prestigious awards and has written numerous prominent books, including Who Believes in Human Rights and the award-winning When Humans Become Migrants. In 2019, she was awarded an ERC Advanced Grant to lead a 5-year research project on Dissect, Evidence in International Human Rights Adjudication. Dissect explores the evidentiary regimes of the world's 3 regional human rights courts and 2 UN quasi-judicial bodies. It asks questions of special relevance in our post-truth era, such as how and when a fact is considered to be established, and how do human rights judges navigate factual uncertainty. Professor Dembour, it's a huge pleasure to have you with us. Over to you.
Thank you very much. And thank you to Helena. Thank you to Helena for writing this absolutely fantastic book. Now, Helena, in your book, you thank your husband for being bloody fantastic. And I want to thank you for writing a bloody fantastic book. I mean, I really mean it. You've given us an introduction, and I think the book is so rich that maybe for some of the audience, it will have been difficult to take it in. But what I want to say is your book is an absolute model of clarity. I mean, it is so clear. You write, your arguments just flow, and I like the fact that you are passionate about them. You really believe in the right to family life. You really explain why, as human beings, we do need, we rely on family members. Family is very important to the great majority of us. And, family life, our needs and our relationship in family life fluctuate over our lifetime, but it's often a constant that we actually either can rely or wish we could rely on family members. And so that's one of the reasons why this right to family life and to family reunification is so important. Because if you are separated from your family members, you no longer can develop this family life, but also be able to care for each other as human beings expect. Now, as I said, you are very passionate about it, and it's very clear, but you also manage to be completely, in a sense, dispassionate about your arguments, because you really go into the law and how the legal reasoning works out. You are extremely well informed. So it's never a very constricted kind of, or one, or it's legal argument, but it's legal argument put in a political context, in a social context, in an understanding of what it means to be human. So what I would say, it's always being very engaged and engaging. And at the same time, because you are aware of that context, you always try to be extremely well balanced. So you look at the different aspects, but you also look at what is it like for these judges? Could they possibly make this argument? Or if I was asking them to make this argument, would I ask them in a sense to go too far? Because I being Helena, not me, Marie, but being Helena, I try to understand what their constraints are going to be and what kind of, what may be going on in their mind. And that makes for extremely rich and extremely insightful analysis. It's really a pleasure to read. And in fact, when I was preparing for today, I was thinking, what I would wish to do is just to read out some pages to the audience so that they can appreciate this beautiful prose. And as I say, the clarity of what you expose and the compelling, also the compelling quality of your arguments. Now, you know, the introduction has referred to the fact that I have written a book on the migration case law of the European Court of Human Rights, and no doubt that's why, you know, you included me in a sense in giving you comments on drafts of the book, but also on being here today. So so this is what I'm going to talk about a little bit more. Now, what strikes me is that in my book, which is rather thick, 500 pages, family reunification appears. I do talk about the case that lawyers will recognize, Abdulaziz Cabalez and Balkandali versus the United Kingdom, and following case law, but in a sense, very little. But one of my, our conclusions, nonetheless, are rather similar. It's, well, you know, there is not a right to family reunification as such. So it's difficult to engage Article 8. And at the same time, it's not that there is absolutely nothing. But in a sense, the European Court, now I talk about the European Court of Human Rights, and of course that's quite important because then the Supreme Court of the UK is going, in a sense, to have to follow the Strasbourg Court. So if the Strasbourg Court is not very generous, well, there is less, there will be less an obligation for the Supreme Court, legal obligation to have a wide interpretation of Article 8. So the two interrelate in that way. So in a sense, that's one of the bases, is to understand what the European Court of Human Rights has said about the case law. And basically, if it goes down to it, it's really that you need pretty drastic personal circumstances for the European Court of Human Rights to be persuaded that you have a right to family reunification. In other words, that the state cannot make it impossible for you to be reunited with your family in the relevant European state. Now, one of the questions you ask in your book is, okay, so, right to family life. Okay, right to family life. Well, maybe one of the components is not to be separated from your own family members by the state. And this obligation for the state then not to leave you separated from your family, is that a negative obligation? So it's just the state with nothing to do, just let you be together, just don't interfere, and then you have your right to family? Or would it be a positive obligation? So that if it's a positive obligation, it means the state has to do something. In this case, has to give you a residence permit or a visa or whatever it is, but in a sense, authorize you to be on the territory. So that would be doing something. And you explain very well in the book, and I cannot go into the details here, but you explain very well that although the negative obligation route can be legally persuasive, and that some scholars would really want the courts to go that way, that for strategic reasons, in a sense, you are quite happy rather to push for a positive obligation. And I think it's one of the things I like as well about your scholarship, is that you always go to look for what is possible. Maybe there is an ideal, but the ideal is not going to happen. So why don't we go for recommendations which allow us to go forward? And that is something that, in a sense, you say all along. You also say, okay, you can criticize human rights. Human rights have not delivered. Human rights law has not delivered in this area. And so one could take a very, very cynical view. At the same time, let's not do that, because if we do that, we have nowhere to go.
2 more minutes.
Much, much more better to kind of see where there can be progress, where we can have advances. And so that's what you are really looking for in the book. Where have there been advances? Where have there been, in a sense, retreats? Where has it been disappointing? But nonetheless, there remains some hope. Where can we push? And as I said, you do that in a way which encompasses legal reasoning, but also the social context, the political context, and also, in a sense, moral values as well. I mean, this is not a value-neutral book. This is a book where you say, okay, we need to look at it. And also, I want to repeat that. I mean, the language you use is always so beautiful. So maybe I will end by 2 quotes. I mean, the thing is, I could have quoted so many things, but and maybe out of context of the book, it will not sound so striking, but I can tell you, potential readers, that actually it makes perfect sense in the book. But one thing: what is family life if not the underlying obligation of care, interdependence, and support, performed in different ways over the life cycle between different individuals, as opposed to which you say that, of course, the states much prefer a narrow approach of the Strasbourg Court to family life, where they approach family life as an artificial and static concept, so completely divorced of normal obligations. And also, you say, okay, what does the Strasbourg Court does? It looks at immigration control as it was, and that's a force of nature, a monolithic entity that cannot be avoided or negotiated, end of quote. And so for the court, immigration control is just there and could escape scrutiny. And what you ask is for the court to actually bring a scrutiny of immigration control within it, not just accept it, and certainly accept that family life is an important weight. It cannot also just be looked at the abstract as something which is allowed or not allowed under immigration control. One needs to take seriously family considerations. And I'll stop here because I'm sure I've exhausted my 2 minutes.
Thanks very much. Oh, some great comments there for you, Helena, about your writing style as well as the content. So that's really great. Thank you. Let's go on to our next respondent, Dr. Jo Wilding. So Dr. Wilding is lecturer in law in the School of Law, Politics and Sociology at the University of Sussex. Her research specialism is legal aid and access to legal advice, particularly in immigration and asylum, and she has undertaken research commissioned or funded by the Welsh Government, Refugee Action, Paul Hamlin Foundation, the Community Justice Fund, the Greater London Authority, East of England Local Government Association, and Joseph Rowntree Charitable Trust. She teaches public law and migration law on the undergraduate and MA courses and co-supervises the Sussex Migration Law Clinic. She was previously a barrister specialising in immigration, asylum, and unlawful immigration detention cases at Garden Court Chambers in London, where she remains an associate tenant. She regularly worked on cases for unaccompanied children and victims of human trafficking. She contributed to several editions of the main practitioner manual, MacDonald and Toll, Immigration Law and Practice, and designed and delivered training for immigration solicitors and caseworkers. She's a member of the Immigration Law Practitioners Association. She also worked at Bristol Law Centre as a casework assistant before qualifying as a barrister. And before all of that, she was a clown in a circus in Iraq and wrote a book called Don't Shoot the Clowns about the experience. Fascinating. Over to you, Dr. Wilding.
Thank you, Nick. I forgot that was there on the end of my profile. Thank you so much, Helena, for inviting me. I was very flattered to be invited in the first place to the group of critical friends who were sort of helping you get to the end of the process of writing the book. And as quite a new academic, it was a great privilege to get to spend time in this virtual room with these three extraordinary women and extraordinary academics. And I learned a huge amount from being in that virtual room with them. But it also brought back memories from my time in practice. I was quite a new practitioner when the Huang House of Lords decision came out. And the rest of the cases that Helena analyses really infused my time as a barrister. I was lucky enough to have been supervised by Sonali Naik, now King's Counsel, and to have been at Garden Court Chambers, who were involved in quite a few of these cases. And I think the best way that I can explain the impact of these cases is to describe kind of how we argued Article 8 cases before and after these. But as I do that, imagine that you're the client having your family life defended in each of these ways. Because as lawyers in practice, we define and create our clients' stories to make the most compelling case in law, but those people have to listen to their family lives being laid out in these ways. So what came before the Supreme Court decision in Huang was the Court of Appeal decision in the same case. And there had to be family life that was worthy of respect, which would be interfered with by the decision to remove the person. And in addition to that, the state's action had to be necessary to protect some legitimate aim and proportionate to that legitimate aim. But even if it was disproportionate, you also had to argue that there was some additional element of exceptionality, something, quote, beyond the normal emotional ties. So your client had to be more vulnerable or more dependent or more needy somehow than the hypothetical normal person who just wanted their family together. And really, it's precisely the ordinariness of that request to have your family together that is compelling. In Huang, it was a widowed mother wanting to stay in the UK with her adult child and her young grandchildren. In other cases, it's been the young adult child of someone granted refugee status, a husband or wife who doesn't meet the rules for whatever reason. After Huang, it was enough that the state was proposing a disproportionate interference with your family life. That sounds obvious. It meant that you could rely on the positive aspects of this person having a family life and family ties with their family members in the UK. So that really changed the way that you would talk about your client's case. And then came the sort of the first post-Wang phase of Bioku Betts, Chikwamba, EB Kosovo. And Bioku Betts said that there is one family life, and all of the impacts of separation on all of the family members could and should be considered in one appeal. And again, it sounds blindingly obvious, but before Bioku Betts, we had to concoct this ridiculous account of how the appellant, the person that was facing removal, would suffer distress at being separated from their partner and their child, but would also experience this enhanced distress because of knowing that their partner and child were also distressed by the separation. The child's distress in itself wouldn't be taken into account because they were not the appellant. They were not a party to the appeal. In theory, the child could then, through a litigation friend, make a separate application under the Human Rights Act in which their own Article 8 rights could be considered. After Bioku Betts, you simply put forward all the evidence in relation to how separation would affect all the family members. And that just seems like common sense rather than anything wildly radical. Then Chikwamba came along and the court said it is a disproportionate interference with family life to require someone to leave their home, their partner, their young child, or to separate the child from their other parent, merely for that person to go and make an entry clearance application from abroad, particularly when the outcome of that application is very clear. So they talked about elevating dogma, elevating policy to dogma. So it's yet more common sense, really. It still allowed the Home Office to refuse applications which didn't meet the rest of the rules, or to refuse where there were egregious breaches of the rules, but in the past, but where the previous rule had affected a much wider group of people than that who were likely to be refused. And we've had a client in our law clinic at Sussex this year who's very much in that same position. Husband and son are British. They decided as a family to come back to the UK because things were not very good in her country of origin, and it also just made sense to move then as the child would be going into secondary school. Husband arrived first to take up a job and to get the 6 months worth of pay slips that they would need to make her application for a spouse visa. She and the child arrived a bit later when his school finished with a visit visa for her. And obviously the child didn't need one being British, so they would be together in the meantime while they waited to be able to make the spouse visa application. She would settle the child into school, and they'd made these plans very carefully based on very careful, very thorough research. She would then go back to her country of origin, apply on the super premium service, and be back here within a week or two. Now, that premium service was suspended because the Home Office had moved most of its staff to processing the Ukraine visas. And it was going to take at least 6 months. She would be away from them for at least half a year. The child was in his first year of secondary school. The school was relatively far from their home because they had to apply for school places outside the normal window. So he needed driving there. Dad was working. So real practical difficulties, never mind the prospect of at least a half-year separation and her having no home in the country of origin and so on. And those are the kinds of cases that we were talking about. Before Chikwamba, the Home Office could simply insist that she returned. And after Chikwamba, in those clear-cut cases, they had to process the application in country. And of course, you then had to argue in court potentially over how clear it was that they would get a grant of leave if they went back to their home country. But it was no longer the position that the Home Office could insist she left the UK for the sole purpose of applying to come back if it was going to mean months of separation. In EB Kosovo, the court decided that Home Office delays were relevant to considering the family and private life that someone had developed in the UK. And that maybe had a less dramatic effect on how, at least I argued cases, but it did just save having to reinvent that particular wheel every time that your client had developed a relationship and had had children while the Home Office had failed to deal with their case, maybe over a period of years. And we did celebrate these as a sector. as practitioners, because they recognized our clients as human beings whose family lives were not devalued by the mere fact of being foreign. And I won't talk about all the rest of the cases for the sake of time, and also because that last tranche are a bit more depressing. But I did just want to mention ZH Tanzania, which is in Helena's kind of second post-Huang tranche of cases. And again, what the court said was hardly radical, but it really did feel like a game changer. The best interests of the child had to be taken into account as a primary consideration in any immigration decision affecting them, not the paramount consideration as it would be in the family courts, but a primary consideration that couldn't be outweighed by immigration policy alone. And that meant it was no longer possible to dismiss an appeal without even considering the child's best interests. And it meant you could appeal onwards to the upper tribunal if the first tier judge had failed to adequately consider that. Immigration and asylum law is always a bit cat and mouse. Courts make a decision. Sure, which the government doesn't like, and the government attempts to legislate that away. And as Helena said, there's also this sort of power struggle between the government and the courts. And so it is with Article 8. And what we see in the last tranche of cases that Helena analyses is sort of the taking back of some of those gains which recognise the humanity of migrants. The new immigration rules in 2012 that started to make it much harder to qualify for leave to remain in the UK, particularly on the grounds of family life or of long residence. Legislation like the Immigration Acts of 2014 and 2016, which all fed into the Windrush scandal, and then the Nationality and Borders Act last year, now the Illegal Migration Bill, all of that alongside cuts to legal aid, especially since 2013, which make it much more difficult for people to access legal representation to vindicate what rights they do have left. So Helena's last chapter is another Article 8 is possible, and I agree. Another way of interpreting it that recognises people as human regardless of their nationality. And we had a hint of that in Huang and the immediate post-Huang cases. Politicians need to stop putting forward those outright untruths about things like being unable to deport an illegal immigrant because he had a pet cat. They need to stop dehumanizing and scapegoating. And as academics and as practitioners, I think that whatever your underlying politics might be, it's important to call this out. And for me, I think Helena's book does exactly that. And I wholeheartedly recommend it. Thank you.
Thanks, Dr. Wilding. That was amazing. Thank you. And we're going to move on to our third discussant, and then we'll take some questions at the end. So Professor Betty de Hart is Professor of Transnational Families and Migration Law at Vrije, Universiteit, Amsterdam. She conducts legal, empirical and historical research on the national, European and international rules that transnational families encounter, the views behind these rules, as well as the impact on the everyday lives of transnational families. Such research provides new insights into the meaning of nationality, citizenship and belonging. It's great to have you with us, Professor de Hart. Over to you.
Thank you very much. Yeah, thank you, Helena, for inviting me to comment. I totally agree with the previous speakers about how wonderful your book is, how wonderful it was to be involved in this project, not only for its content, but I also greatly admired how speedy you were in writing the book. Eventually, the chapters came to us with, a few weeks only between them. You kept us quite busy. And you finished it quite quickly, including our comments. So I always read it as sort of an outsider in the sense that I'm not from the UK, and I read it as a Dutch legal scholar and a European, someone from Europe. So my comments relate to this aspect and the relevance of your book from that perspective. So as a Dutch legal scholar, I was envious for quite a long time of you having a Supreme Court like the one you have in the UK, because the case law that I read, I admired for its lengthy motivations and arguments that went on often for pages and pages, where I think from Dutch perspective, the human aspect was always considered. So even in, for instance, the case on the minimum income requirement that did not turn out positive for the right to family life, I still thought it was very extensive, explaining the line of argument that was taken in that I never saw in Dutch case law, although the Netherlands introduced also a strict minimum income requirement already years before the UK did. So I read it from that perspective. In Dutch case law, often migration law cases are treated like, yeah, it's the same as building a shed in your backyard without a license. So without any humanizing aspect, treating it as an administrative matter, merely a very restrained case law where judges hold back and just merely consider whether the state secretary could have reasonably made this decision. And that for the same reason, I always was very interested in the ECHR case law, so from the European Court, because there too, it goes on for pages, often going into detail of the lives of migrants that I still continue to miss very much in Dutch case law. As a Dutch legal scholar, I also read it from a totally different legal context. In that the Netherlands is bound by EU law, and especially the Family Reunification Directive. Although when this directive was introduced, there was great concern among migration legal scholars that it was below the level of Article 8 ECHR. By now, it is abundantly clear that it is totally different. And it is different because it starts from the principle that member states have a positive obligation to make family reunification possible. Family reunification, not family life, which is totally different, and a positive obligation. This starting point leads to a total different case law, and it goes way beyond Article 8. Still, for instance, the Supreme Court case on forced marriages turned out positive for family reunification rights, while the court case of the European Court of Justice on a similar case of forced marriages did not, so without any critical consideration of why this policy was introduced and the arguments provided by the government. Still, often I tell my students when I teach about migration law, forget about Article 8. First, go to the Family Reunification Directive, because that gives much more positive rights to and much more protection to family reunification. I think it's also important to acknowledge that you, Helena, write it in context of one of the 3 countries, which includes also the Netherlands and Denmark, that have the strictest family reunification policies in the world. So in a global index of family reunification policies, the MIPEX index of 2020, the Netherlands, UK and Denmark are at the bottom of all the countries having the strictest policies. And I think that is relevant to look at what is the meaning of Article 8 within this context. It is offering some sort of protection, if at all, within these very restrictive contexts. Although we're in a context also where migration is very much politicized, it is highly visible in the media, and you have this game being played between politics, media, and courts. Yeah, you point out, Helena, that this is also a context which forces courts to be cautious. But I wonder whether that is really the case. It could also mean that courts need to take a stand against such developments. And but you point out that Article 8 does not leave that much room to actually do that. In many other countries, Article 8 may not be that important, not because it is not taken seriously, but because national migration law is much more liberal. For instance, some of the more southern countries of the European Union or of Europe. I'm often very much a pessimist when it comes to human rights and family migration. Maybe I'm just in it too long. And I'm often looking for some optimism. And yeah, also in your talk, you explained how you sort of move back and forth between this pessimism and optimism. And I think it is really important that you look for room within existing legal frameworks, within Article 8, and that makes perfect sense. This also speaks to the link between academia and practice. And I remember a conversation with a colleague whose partner is a migration lawyer, and he's often very frustrated with us academics and our critical analysis of case law, explaining what the ECHR did wrong instead of what it did right and what is good about it and how he can use it. And in my teaching, I also often use this very critical analysis of Article 8 case law, and my students are often even more critical. And I think your book offers much more what he wants and needs as a practicing migration lawyer than I do in my critical analysis. Still, I want to ask the question. So, yeah, if you stick within the box, as I will call it, of Article 8 ECHR, taking that as a starting point, how can we move beyond that or take in new perspectives and other perspectives? You write in your book that it is understandable that the ECHR takes state sovereignty as a partner in migration law as a starting point, but is that really the case? It is increasingly being challenged, not only by Marie, but also by others like Tendai Atsuma, also people from the academics from the Global South. So how can we, if we stick within this box of Article 8 ECHR, still incorporate these approaches in our analysis as legal scholars, or should we at all? Yeah, and in my teaching, I made this development from starting like 20 years ago or so, talking about national migration law, Article 8 ECHR.
3 more minutes, Betty.
Yeah, okay, that's fine. Then including the Family Reunification Directive, EU law, and now I'm opening it up also on demand of our students, our international students, also to look at other regional courts, at international law, and on other perspectives for instance, from the Inter-American Court. So what the UK and the Netherlands and Denmark do as the strictest countries in the world is not self-evident at all. It is not the norm. And I think it is important to make that clear. So yeah, my question is what I really admire what you do in the book, how you look for this room inside the box of Article 8 ECHR, but also question, so what does it mean remaining in this box and how can we take these other perspectives? Still, your book makes it possible for me to continue to love to hate the box of Article 8 ECHR that we stuck with. And I think it is also, you cannot stress enough how important it is. And I often, in my teaching, end with the clip of, what is it called again? What did the ECHR ever do for us, that you can find on YouTube, inspired by Monty Python, obviously, including wonderful actors as Patrick Stewart. It's not only extremely funny, but also is a very good, important caution, I think, that it's good to be critical of the ECHR and the Supreme Court in your context, but that we also need to be cautious with this critique. And I think your book very much speaks to this, especially in a context where increasingly governments and politicians think that we can do without the two European courts. From that perspective, your book helps me very much, and I guess also others, to keep sane and to remain an optimist. And I thank you very much for that.
Oh, lovely. Thank you very much. So we've heard from three discussants then, Helena, and I wanted to ask you really now, Helena, whether you'd like to respond to those three briefly, or if you'd like to open it up to questions. We've got about 25 minutes, so it's your choice really, what you would like to do next.
Oh, thank you. I mean, just thank you to all three discussants. I mean, you were fantastic supports when I was writing the book. You know, lovely to have you here and talking about it in such an engaged way. And thank you for all the wonderful comments and points you've made. I mean, I would like to open up. If I may just respond a little bit to Betty? And I think this is a really interesting discussion to have, Betty. And, you know, we've sort of had it before. Just, you know, do you stay inside the box? Do you go outside the box? You know, how far? And I'd say a number of things. And, you know, obviously the argument I made earlier, the point I made earlier was very compressed in the sense that I had to kind of leave out a lot of the kind of nuances of where I was going and why I made the decisions I did. But I kind of think, I think that Article 8 could do a lot more. I mean, yes, it couldn't do everything, but it could do a lot more. I think, and I do make this point in the book, that you're right, that, you know, the UK is amongst the most oppressive country states in terms of its family reunification. And, you know, I would say that the European Court has perhaps not been attentive enough to this idea of consensus, you know, that it sort of takes the lowest common denominator instead of saying, well, actually, you know, is it the case that across Europe you have to have these very, you know, all the states have these very restrictive policies, you know, maybe we are out of line. So I think that there is, what I would say is I think there is a considerable amount of room for manoeuvre within the Article 8 arguments. And at the moment in the UK, because we're not in the EU anymore, sadly, Article 8 is in a sense the only game in town. And so, you know, what can we do with that? Actually, I think we could do a lot. And in the chapter, you know, where I talk about that, you know, what we could do with Article 8, you know, if I said they're relatively modest, it's like a modest proposal, but it's actually would make a huge difference. And I think, you know, going back to what Joe said about arguing these cases in court, you know, you find these sort of small but clear shifts can play out in really big ways. So I completely take on your board, you know, I'm kind of putting myself back in the box. I think there's a lot to say about challenging the nation state. I'm very much in sympathy with those arguments. I guess I sort of decided not to make that argument in the book at that point. It was like a different argument to make another time. But I think it's a really interesting discussion that we should continue at another point. And I will now hand over to the rest of the room.